to the moot court competition of the Puerto Rican Bar Association of Florida. I guess this is the national, and we're not here or arguments of counsel. You ready? Proceed? Are you ready? You may proceed. Pardon? I don't see one.
Maybe this is a mic here.
I think that's a mic. Is it on?
I don't know if it's on.
Oh, that better? No.
Maybe it's better, right? They don't hear our voices.
Yeah, you may proceed.
Chief Justice, Associate Justices, may it please the court. My name is Jordan Benbow, and together with
Hold on a
my...
second.
We don't have a clock. Time out.
I'm out. Rewind the clock. Who has the clock? Okay, so you can let us know. All right.
Thank you.
You may proceed.
Thank you. Chief Justice, Associate Justices, may it please the court. My name is Jordan Benbow, and together with my co-counsel, Darren Chambers, we'll be representing the appellant, Mr. Homan. I will be
And what law firm are you from?
from Barry University.
That's what we know.
Huh?
That's what we know.
What? You know, the brief, so I can ask questions regarding the law that's in the brief. I don't know. Okay.
I will be addressing the first issue of local interpretability, and my co-counsel, Mr. Chambers, will be addressing the second issue of substantive due process. We shall rest on our brief for the third issue due to time constraints. However, we are more than happy to entertain any questions in this report. This case is about the legal constitutional rights of the people of Puerto Rico, as set forth in their constitution, and therefore we respectfully request this court reverse the lower court's ruling. May I please reserve 1 minute for rebuttal?
You may.
Well, let me ask a question before you proceed, if I may. You're the appellant, so you are claiming that there was error by the court below.
Yes, Your Honor.
Precisely what error, or it may be errors that the court committed below. What are you saying that the error was?
Your Honor, the contention is there are two errors in the court below. The first being that the statute, the Federal Death Penalty Act, is locally inapplicable as set forth in the Puerto Rican Federal Relations Act, and therefore Congress, for the second point, should have been clear and explicit if it wished its intent was to apply the FDPA to the Commonwealth of Puerto Rico.
Is it locally inapplicable because under the Puerto Rican Constitution, there shall be no death penalty, as it states in the Constitution of Puerto Rico?
Yes, Your Honor.
So that's the essence of your argument, that it is locally inapplicable, the FDPA, by reason of the fact that the Puerto Rican, the Commonwealth Constitution of Puerto Rico, prohibits the death penalty. That's basically the essence of your argument?
Yes, Your Honor, that's the core. However, it is read with the Puerto Rican Federal Relations Act, which Section 9 of the PRFRA, which was enacted prior to the approval of the Puerto Rican Constitution, is where the courts have gotten this locally inapplicable standard from. This is a federally enacted statute. It has created a compact between the Commonwealth of Puerto Rico and the federal government. Now, to your question, Your Honor, the Constitution itself is where the provision for the death penalty shall not exist is found. And reading the Puerto Rican Constitution together with the PRFRA, it is clear that the law is locally inapplicable. However, Congress can and has in the past extended a federal statute that was locally inapplicable. However, they have done so in clear and explicit terms. This is seen in the case of the United States v. Farrer, the First Circuit case from 1980, and also Alcoa Steamship Code v. Perez-Rodriguez, another First Circuit case from 1967. The terminology that the courts used in both of those cases was that Congress unmistakably.
I thought federal law trumped any local law, state or territory or Commonwealth or otherwise. Is that not the rule?
No, it is, Your Honor,
Oh.
certainly. However, we have two federal laws conflicting in this case. We have the PRFRA, which is itself a federal law, and then we have the FDPA. They are both
it excluded?
No, Your Honor. However, this court should look at the plain language of the statute itself, that is the FDPA. And from the plain language, based on the canons of statutory interpretation, it is clear that Congress did not wish to extend the FDPA to Puerto Rico because they have done so in the past. They know the terminology to use for a federal law to apply above a constitutional provision. This was seen in the case of Quinones, in a First Circuit case. In Quinones, it was a wiretapping provision, and there was some controversy as to Title III provision in that case.
Well, in Quinones, really the issue was whether the evidence that was gotten by the wiretap could be used in a Puerto Rican court. The Puerto Rican argument was that it cannot be used because the Constitution prohibits that type of evidence. And that was really the issue there. Does the Constitution of Puerto Rico trumps, as Justice Perez has indicated, does it trump the wiretap law? That was really the issue in Quinones. And what did the Quinones court hold?
Your Honor, the court found that it did not because the First Circuit determined that
Did not what?
the wiretapping provision was not trumped by the local constitutional provision against wiretapping.
So that it was admissible evidence.
It was admissible, Your Honor, because the wiretapping statute was made explicitly applicable to Puerto Rico. It was only the Title III provision within the statute which was not. And the court was able to look at other parts of the statute to determine that Congress did indeed mean for it to apply to Puerto Rico.
But look, I think everyone here would agree that we can start from the premise that federal laws apply to Puerto Rico.
Yes, Your Honor.
Unless there are certain reasons why it cannot.
Time's up. Your time is
Okay, but you reserved
Oh,
some time. Go ahead.
yeah, we'll extend. We'll give you a minute.
Thank you, Your Honor.
Okay. Well, answer the question.
Yeah.
What was your question, Your Honor?
The judge gave you permission to answer the question. That federal law applies to Puerto Rico.
Yes.
We all agreed on that.
Yes, Your Honor.
But you're saying that unless certain things occur, then it doesn't apply. For example, if it's not if it's locally inapplicable, then it doesn't apply. But then, how do we determine whether it's locally inapplicable or not?
Your Honor, in this case, it is being locally applicable due to a constitutional provision which was approved by Congress.
But the problem that we have here is that it did not say yes, Puerto Rico is excluded. It did not say no, Puerto Rico is not excluded. So how do we determine whether it's applicable?
Your Honor, in the past, the First Circuit has always looked to the plain language or the congressional intent, and typically the verbiage used by the court is that it was unmistakable and it was clearly expressed. In this case, it was not. Therefore, it should not apply.
So you say failure to expressly state that Puerto Rico is excluded means that it applies, or failure not to expressly say that Puerto Rico is not excluded, then it applies.
Yes, Your Honor. Failure to state clearly that it does apply.
It doesn't.
Isn't
The
implied.
FDPA, you're saying.
Yes.
So the FDPA, the bottom line is, does not clearly or unmistakably make it locally inapplicable.
Yes, and therefore, based on the PRFRA, it is locally applicable and does not apply. Thank you.
Okay. Thank you. Okay, let's hear the rebuttal to the appellant's argument. You're on the second argument.
The second issue.
All right, let's hear the rebuttal to the first, so that we can better judge.
No pun intended.
No pun intended. Morning.
May it please the court. My name is Alicia Suarez. My name is Alicia Suarez, and I will be discussing the locally applicable issue here. The federal death penalty is locally applicable to Puerto Rico. The Puerto Rico Constitution was adopted in order to organize local government. It It was not adopted in order to circumvent federal law. Therefore, this federal death penalty should be applied to the defendant in this case.
But you heard the argument by the other side that because it was not expressly stated in the FDPA that it would be applicable to Puerto Rico, therefore it cannot be applied to Puerto Rico. What do you say to that argument?
Well, in United States versus Quiñones and in United States versus Herrera, both times the wiretapping provision did not expressly include Puerto Rico, and the court found there that the Puerto Rican Constitution was adopted and the Federal Relations Act was adopted to apply to purely local matters. So what we must do is also look at the Federal Relations Act and the congressional history, as the appellant has stated. They do look at the congressional intent, and here we must actually look at the congressional intent of the Puerto Rican Relations Act.
You're saying that in Quiñones it was not Puerto Rico was not excluded, specifically excluded.
Correct.
But yet it was applicable.
Correct.
And you're saying in this particular case, Puerto Rico was.
Therefore, we can apply it. So a locally inapplicable matter would be a matter of purely local Puerto Rican charges and not actually.
Well, but the argument is it's locally inapplicable because of the will of the people espoused in the Constitution prohibition against death penalty. So that has some kind of weight. Then you tie that with the fact that in this particular instance, the FDPA does not have a clear intent that it will be applicable to Puerto Rico. Therefore, the appellant is concluding that it's not locally applicable. How do you get around that? The tie-in with the Constitution and the tie-in with the lack of express intent?
I think, again, we have to look at the Federal Relations Act, the compact between the United States and Puerto Rico, and the purpose for allowing the Puerto Rican Constitution and for the people to come together and localize their government was to address local matters. Prior to the Federal Relations Act, Congress could come in and apply federal law to local matters. So the compact between Puerto Rico and the United States, along with the that ratified the Puerto Rican Constitution, was not there to address federal matters. It was there to address the purely local matters. So where the congressional intent does matter, we also have to look at the Federal Relations Act and Compact. And even though the federal death penalty does not expressly exclude or include Puerto Rico, it does expressly exclude Native American tribes. So we would have assumed that Congress would have expressly excluded Puerto Rico if its intent was to do so also.
3 minutes.
Okay. So
You're saying expressio unius alterius exclusio alterius?
yes, Your Honor. I believe that if Congress intended to also exclude another territory, it would have expressly done so within the Federal Relations Act. And here, it's only the Native American tribes that it felt to exclude.
And you would agree that expressio phrase is a Puerto Rican phrase, right?
We feel that the Puerto Rican Constitution was not adopted in order to circumvent federal laws. Thank you.
Thank you.
Thank you.
You may proceed.
Hey, police court. I'm Darren Chambers, and I also represent the petitioner, Mr. Guerrero. This case is about federal death penalty application without representation. Respectfully request that this court reverse the first circuit's decision and hold that application of the FDPA petitioner does violate the substantive due process rights for the following 2 reasons. First, citizens of Puerto Rico do not have proper representation. And second, death is substantially different, and applying it to citizens of Puerto Rico violates its shocks of conscience. So my first reason, this court over and over again has stated that voting is a fundamental right that was in Cardona v. Powers. In Riddle v. Sims, this court says the right of suffrage is a fundamental matter in a free democratic society.
Do you think voting is a key issue here? Let me posit this scenario. It's a hypothetical, but I want to see how you would react to this situation. Let's say an American citizen who has lived in the United States all of his or her life, and therefore has had representation in Congress, temporarily moves to Puerto Rico, and for whatever the reason decides to commit a crime that comes under the FTPA. Would that person be able to make that argument? Because that person, through all his or her life, was in the United States and had the opportunity to vote and therefore be represented. Would that person make that Fifth Amendment substantive due process argument?
But yes, Your Honor, this right that extends to the citizens living on the island of Puerto Rico.
But this person had the right all of his or her life to be represented by Congress. So that person cannot argue that that law was passed without him or her being represented.
Yes, Your Honor. The difficulty there would be determining who's resided in Puerto Rico for the duration of their life and who's had representation, whether that representation was adequate. What we're asking here is that the Federal Death Penalty Act, since it violates substantive due process rights of the petitioner and people of Puerto Rico who have not had representation, that right.
So in the scenario that I'm painting to you, you're saying that the dispositive fact is residence in Puerto Rico, not whether the person has lived all of his or her life in the United States and has had representation in Congress. So you're saying that the dispositive fact with respect to substantive due process is the fact of physical presence in Puerto Rico.
Your Honor, it would be difficult again to ascertain who's had the proper representation. For that matter, it's specifically to a petitioner who's resided in Puerto Rico his entire life, has not had representation.
And that's the case here. I was just throwing a scenario to see how you would look at the application of the Fifth Amendment substantive due process claim.
So are you saying that in its origin, ab initio, the Puerto Rico Federal Relations Act basically should be repealed, or somehow it's not applicable? Because back in the 50s, we didn't have representation in Congress either down in Puerto Rico. So I'm not quite getting what the argument is. In other words, today, so many years later, you're saying all of that happened back in the 50s is no good because it violates the substantive due process of the Puerto Ricans in Puerto Rico because they don't have representation in Congress.
No,
well, they didn't have representation back in 1950 and 51 either.
And no time and type. It's the one penalty that is irreversible. It's final.
Well, if it's okay, so you're saying in Puerto Rico is because this death is different, that it shouldn't apply. Now, how would that juxtapose itself against the death penalty in the other states that don't have the death penalty?
Your Honor, in Michigan, in their constitution, they have abolished the death penalty. But those states have had representation. Those states don't have the Puerto Rico.
What difference does representation make? If the federal code applies to the United States, correct?
Yes, sir.
And in the definition, Puerto Rico is included in the United States, correct?
Yes, sir.
So doesn't that indicate that Congress had an intent that all of the provisions of the code would be applicable to Puerto Rico?
Your Honor, it's the shocks and conscience standard which rules the violation of substantive due
Whose
process.
conscience are we shocking?
It's ours. It's the people's. It's something that's so rooted in traditions and conscience. And our traditions are the right to vote. That's fundamental.
Well, what if it shocks my conscience? Does that mean it doesn't apply to me?
I'm sorry, Your Honor.
It shocks my conscience. Does it mean it doesn't apply to me?
No, Your Honor. It's not set to the individual. The individual's conscience. It's set to the people's. Our traditions, our culture, and our tradition as a country is that the fundamental right to vote is necessary in a free society. The peoples of United
Government.
Thank you, Your Honor. The United States citizens do not have, in Puerto Rico, do not have that fundamental right to vote for the president who appoints the U.S. attorneys who seek the death penalty, to vote for members of Congress who vote for acts like the Federal Death Penalty Act and hold this act.
So you're saying Puerto Rico should have, if they had 5 representatives, they would overturn this?
No, Your Honor, but that would give them fair representation of votes move legislation in one direction or another. It wouldn't be enough to change something, but it might have had an effect if they had that representation at the time the Federal Death Penalty Act was enacted. You know? And for these reasons, we respectfully request that this court reverse the first decision. Thank you.
Thank you.
Thank you.
You may proceed.
Thank you, Your Honor. Good morning, Mr. Chief Justice, and may it please the court. My name is Ashley Aguilar, and I too represent the United States. I will be discussing whether applying the federal death penalty to defendants violates the substantive due process. However, before I begin, I'd like to address three of my learned adversaries' points. To begin, it is true that voting is a fundamental right, and it is never this government's position to deprive someone of their right to vote. However, Puerto Ricans have voted to not have a vote in Congress. Secondly,
They have voted to do what?
they have voted to remain a commonwealth and not become a state. Thus, they've voted to remain the same.
But that irrespective of whether they have voted not to join the United States and therefore vote in Congress, does that mean then that the PRFRA, we're supposed to ignore it when it says that certain laws that will be passed by Congress will be locally inapplicable?
No, Your Honor, that is not what I'm arguing here. It's the United States government should and does recognize the Puerto Rican Federal Relations Act and all of its facets in Puerto Rico and its relationship to the United States. Secondly, I'd like to address the fact that death is different. And this government recognizes that death is qualitatively different. And notwithstanding the irrevocably grave nature of the death penalty, because the defendant is being charged with a federal crime like any other American citizen, here it is just not egregious enough to shock the conscience. Now, when we look to whether or not something is egregious, we look to whether it's so brutal and so offensive as to offend traditional notions of fair play and decency. And, Your Honors, that's simply not what we have here.
But your adversary's contention is not solely one or the other, meaning that we have not been given the right to vote and that the death penalty shocks the conscience. The way I understand his argument is that a combination of both is so bad that it violates the Fifth Amendment. And as you know, the Fifth Amendment simply says that no person shall be deprived of liberty, property, life, etc., without due process. And what they're saying is that there is no due process here because the person that is being affected by the deprivation of, in this case, of life, has not had the opportunity to voice something with respect to how that is going to affect them. And that's the argument there. Is that a valid argument that because we have not had the right, and when I say we, that's the argument of the appellant, we have had not the right to have a say-so as to
Essentially sentenced to death under the federal death penalty like any other American citizen. Similarly, if we look to City of Sacramento versus Lewis, there a driver was involved in a drunk driving accident, and while he was unconscious in the hospital, a doctor performed a drug test on him. And the driver was then convicted with that drug test. There, the court held that notwithstanding the fact that the patient did not consent to the drug test, that was not egregious enough to shock the conscience.
The question is whether they can be equated, taking the life of someone versus taking blood from someone who's unconscious. Reasonable people could differ that one is more egregious than the other, that one would shock the conscience. Actually, some people may even consider that taking blood out of an unconscious person may shock the conscience. But really the question is, are those similar so that the standard of shocking the conscience can be applied to both equally? That's really the issue.
Here are two responses to your question. One, it is clear that taking blood and taking life are inherently different. The government does not equate taking blood and taking life, Your Honor, because death is different. And to the second point, Your Honor, the same court in the City of Sacramento versus Lewis held that what may be egregious in one instance might not be in another. Thus, the courts must conduct an exact analysis of all of the circumstances before they can hold whether something shocks the conscience.
But again, I go to the point that, of your opponent that he is not saying that shocks the conscience by itself may be enough. What I believe his argument is that in conjunction with the lack of an ability to vote on that combination shocks the conscience and is violative of the due process clause of the Fifth Amendment.
Your Honor, I understand your concern. However, the fact that Puerto Ricans do not have a vote in Congress is a political question here, and not for the courts to decide. However, notwithstanding their lack of voting representation in Congress, because Puerto Ricans have the same benefits and protections under the American Constitution as every other American citizen, they must be held to uphold the standards of that same Constitution, just like any other American citizen.
Except for the PRFRA, which sets certain limits.
Yes, Your Honor.
I have a question for you, counsel.
Yes, Your Honor.
The Puerto Rican Constitution explicitly states that there shall be no death penalty.
Yes, Your Honor.
Okay. So what if they just sentence Mr. Pujols to death? The judge down in Puerto Rico sentenced him to death. And then they just take him to Atlanta, Georgia, to a federal prison and execute him over there. He's not in Puerto Rico. So they're not really violating the terms of the Puerto Rican Constitution because they're not killing him in Puerto Rico. They're killing him in Atlanta.
Yes, Your Honor. However,
in other words, the federal government would be respecting the Puerto Rican Constitution by not executing him in Puerto Rico, because Puerto Rico has a constitution that says there shall be no death penalty.
No, Your Honor. According to the Puerto Rican Federal Relations Act, statutes except hereinbefore or hereinafter provided for that are not locally applicable shall not apply. And since the crime occurred in Puerto Rico and he was sentenced to death in Puerto Rico, it would be a violation of the compact between Puerto Rico and the United States.
But that's not what the Puerto Rican Constitution says. If you read it literally, it says there shall be no death penalty. It doesn't say that somebody can't be sentenced to death. It just says that the penalty cannot be imposed. So, all the feds have to do is just transport the man to some other federal jurisdiction in the United States where they have a gas chamber or however they do it, or lethal injection, and just execute him, and therefore not in Puerto Rico. Time is up. No, but I'll allow the camera arguments. Go ahead. Say it again. Tell me again how that doesn't basically cut into your essential argument that you made.
Thank you, Your Honor. The Puerto Rican Constitution, the spirit of the words, perhaps Your Honor's hypothetical explains the words themselves, but the spirit of the law is that the death penalty shall not apply to the Puerto Rican citizens as a whole. It would be illogical to apply a different meaning to those words. Thank you, Your Honor.
But now, if we agree with you, would not all of the criminals move down to Puerto Rico because they have impunity, don't have to worry about the death sentence?
Your Honor, it is not clear whether they would or not, and I am not in a position to state otherwise. However,
but maybe one way to look at it is whether the individual is killed in Puerto Rico or it's killed somewhere else in the United States. The bottom line is that the individual will be killed. First of all, will be facing the death penalty. And the death penalty is applied whether the individual gets killed in Puerto Rico or gets killed somewhere else in the United States. Bottom line is the individual gets killed in violation of what the defendant says is a law that is inapplicable to him.